Hello, my name is Adrian Lifely. I've worked as a dispute solicitor in London for the past 30 years. I'm also an accredited mediator. In this series of videos, I'm going to share with you key information about dispute resolution that I've picked up over the years. The series is called Straight to the Point of Dispute Resolution because that's what I'm going to do. I'm going to go straight to the heart of important issues without any frills or waste of your time. In this video, I will discuss litigation funding. It is the first video of 2 videos about this topic. Litigation funding is where an investment fund pays the costs of your litigation or arbitration in return for a share of the winnings if the claim is successful. It is non-recourse funding. If you lose the case, you don't have to repay the funder for the costs paid out. This is the risk that the litigation funder takes, that if the claim is unsuccessful, it loses its investment in terms of the legal fees expended on bringing the claim. If, as well as litigation funding, you take out insurance against the risk of having to pay your opponent's legal costs, you also have to fund any adverse costs orders against you if you lose the case. What this adds up to, therefore, is that litigation funding combined with insurance against adverse costs is a means of eliminating the costs risk of litigating. The question I want to answer is, should I use litigation funding? And as usual, I'll answer by going straight to the key points. First, litigation funding can't be used for speculative claims. This is because funders will only back strong claims. They won't risk their capital on claims that are unlikely to deliver a financial return for them. Don't therefore expect a litigation funder to fund the costs of weak or speculative claims to be brought in the hope of extracting a settlement offer from the defendant in order to avoid litigation. 2. Litigation funders will only fund the costs of bringing claims, not the costs of defending claims. It's for claimants, therefore, not defendants. This is because funders make their return from damages recovered by means of the litigation. If you're a defendant and you don't have insurance for defending claims, you'll therefore need to fund your own defence costs in the normal way. If you're a defendant with a strong counterclaim, with a greater value than the claim against you, you might still be able to obtain litigation funding. 3. Litigation funders won't fund low-value claims. This is because there won't be sufficient recovery in terms of damages paid by the defendant in order to deliver an acceptable return on investment for the funder. Different funders have different risk profiles and different minimum claim values. But as a rough guide, I would say it's difficult to find litigation funding for claims valued at less than several millions of pounds. 4, and lastly, what does all this mean? It means you should consider litigation funding where you have a strong claim and you are willing to share your winnings with the funder. You might be prepared to do this in return for 2 benefits. Firstly, the cash flow benefit of having a third party pay your legal bills as they accrue, and secondly, for eliminating the risk of losing the case and having to pay both parties' costs. In the next video on litigation funding, I'll consider the position of a defendant who is faced with a claimant who has litigation funding. As always, these are the key points to keep in your mind. Please take legal advice about your specific situation before reaching any decisions.